Hello and welcome. Settle into comfort. Let your breathing slow and deepen. Tonight, we journey into one of the most extraordinary legal cases of the Victorian era. A case involving a shipwreck, a grieving mother, a man who claimed to be someone he could not possibly be, and a trial that stretched across years, consuming thousands of pages of testimony about tattoos, childhood memories, and the question of whether a man can forget his own identity. This is the story of the Tichborne case, though it went by many names. Tichborne versus Lushington, Regina versus Castro, the trial of the Claimant. It is a story of loss and hope, delusion and fraud, identity and imposture. It is a story told through endless details, minute examinations, repetitive testimony that went on for days, for weeks, for months. Let yourself relax. This tale will unfold slowly, as all the best tales do. As the case itself did. Before we reach the shipwreck, before the loss and the grief, let us begin with the family itself. The Tichbornes are an old family, an ancient family, one of those English Catholic families that traces its lineage back centuries, through persecution and survival, through changing times and unchanging traditions. The Tichborne family seat is Tichborne House in Hampshire, south of London. The house sits on an estate of thousands of acres, farmland, forests, tenant cottages. The Tichbornes have held this land since the Norman conquest, or so family tradition claims. Nearly 1,000 years of continuous ownership, passed from father to son, generation after generation. In the 19th century, to be a Tichborne is to be someone. Not the highest aristocracy, they are baronets, not earls or dukes, but old, respected, wealthy. The kind of family that matters in their county, that holds positions of local authority, that everyone knows. Sir James Tichborne holds the title in the 1820s and 1830s. He is the 10th baronet, a position that carries weight, history, expectation. He marries, as men of his class do, and has children. The eldest son will inherit everything, the title, the estates, the responsibilities. This is the way of primogeniture, the ancient English system that keeps estates intact by passing them whole to the firstborn son. Sir James's eldest son is named James, called James Francis. But young James Francis dies. The heir is gone. The title and estates must pass to the second son. The second son is Roger Charles Doughty Tichborne, born on January 5, 1829. Roger is now the heir, the future baronet, the one who will inherit Tichborne House and all that comes with it. From childhood, he is raised with this knowledge. He is the heir. The estate will be his. He must be prepared. But Roger is not an easy child, not a conventional heir. He is slight, thin, perhaps sickly. He does not take naturally to the outdoor pursuits expected of a country gentleman. He is sensitive, thoughtful, perhaps too thoughtful. There are whispers that he might be better suited to the church than to managing an estate. Still, he is the heir. There is no alternative. His younger brother, Alfred, is the spare, but Roger is the heir. He must be educated, must be prepared, must learn to take his place. Roger Tichborne's education follows the pattern expected for a boy of his class and position. He is taught at home initially, by tutors and governesses. He learns Latin, learns history, learns the things a gentleman should know. But there is something else. The Tichbornes are Catholic, one of the old Catholic families that never converted during the Reformation, that maintained their faith through centuries when to be Catholic in England meant disability, exclusion, sometimes danger. By the 19th century, Catholics have been emancipated, given rights, but the old families still maintain their identity, their sense of being different, of holding to the old faith. And so Roger Tichborne, like many sons of Catholic families, is sent to France for part of his education. France is Catholic, properly Catholic, and it is where English Catholic boys can be educated in their faith without the complications of English Protestant society. Roger spends years in France. He attends school there, lives there, becomes fluent in French. More than fluent, French becomes, in many ways, his primary language, the language he thinks in, the language he is most comfortable with. He speaks English, of course, speaks it perfectly well, but with perhaps a slight French accent, a French turn of phrase here and there. This detail will become important later. Remember it. Roger Tichborne, heir to an English estate, is more French than English in his education and manner. French is his language. He also learns other things in France. He develops interests, pursuits, friendships. He is young, away from home, experiencing a wider world. He writes letters home, letters in French and English both, telling his family about his studies, his life, his thoughts. When Roger returns to England as a young man, perhaps 20 years old, he is meant to settle into his role as heir. He should learn estate management, should prepare to take over when his father dies, should perhaps think about marriage, about producing the next heir to continue the line. But Roger is restless. England feels small, confining. He has seen France, has lived abroad, and he wants more. The world is large, and Roger Tichborne wants to see it. This restlessness is not unusual for young men of his class. Many went traveling, took grand tours, saw the world before settling into their responsibilities. Roger proposes a journey. He will travel to South America, perhaps to Chile. He will be gone for some months, will return when he has satisfied his wanderlust. His family agrees. Let the boy travel. He will return soon enough, will settle down, will accept his duties. A few months abroad will do no harm. But Roger Tichborne will never return. Not in any way his family will recognize. In 1853, Roger Tichborne books passage on a ship. He will sail from England to South America, will spend time traveling there, will return by ship when he is ready. The journey out is uneventful. Roger arrives in South America, travels through Chile, writes letters home. His family receives these letters, reads about his adventures, perhaps worries a little but knows he is safe, knows he will return. In April of 1854, Roger Tichborne boards a ship called the Bella. The Bella is sailing from Rio de Janeiro to Jamaica, and Roger intends to take passage to Jamaica and from there find transport back to England. It is time to go home. He has travelled, has seen what he wanted to see. Now he will return to Tichborne House, to his family, to his destiny as heir. The Bella leaves Rio de Janeiro on April 20th, 1854. It carries cargo and passengers. Roger Tichborne is one of these passengers, traveling in a cabin, probably spending his days reading, writing in his journal, watching the ocean pass by. The voyage should take a few weeks. Jamaica is not so far. The route is well traveled, known, safe enough by the standards of the time. Ships make this journey regularly. There is no reason to expect trouble. But the sea does not respect expectations. The sea does what it will. On April 25, 1854, 5 days after leaving Rio de Janeiro, the Bella encounters a storm. We do not know the exact details. No one survived to tell the full story, but we can imagine it. Dark clouds gathering on the horizon. The wind picking up, the waves growing larger. The captain perhaps ordering the sails reduced, the crew securing cargo, the passengers told to stay in their cabins. The storm worsens. The wind howls. The waves crash over the deck. The ship pitches and rolls, driven by forces it cannot resist. Water pours in. The crew works desperately to pump it out, to keep the ship afloat, but there is too much water, the storm is too strong, the ship is taking on water faster than it can be removed. The Bella is sinking. What happens in those final moments? Do the passengers know they are going to die? Is there panic, or a strange calm, the acceptance that comes when there is no escape? Do they pray? Do they think of home, of the people they will never see again? Roger Tichborne, 25 years old, heir to Tichborne House, is somewhere on that sinking ship. Perhaps in his cabin. Perhaps on deck. Perhaps trying to help. Perhaps frozen with fear. We will never know. The Bella goes down. The storm passes. The sea becomes calm again, as if nothing had happened. Days later, debris from the Bella is found floating in the ocean. Pieces of the ship, cargo, personal effects. A few bodies are recovered, but most are never found. The ship carried perhaps 20 or 30 people. All are presumed lost. Among the presumed dead is Roger Charles Doughty Tichborne, heir to the Tichborne estates. News of the Bella's loss reaches England slowly. In 1854, communication across the Atlantic takes weeks. A ship must carry the news, must arrive in England, must report what has been learned. By the time the Tichborne family hears about the Bella, it has been weeks, perhaps months, since the ship went down. The family is devastated. Sir James Tichborne, Roger's father, receives the news with the stoic grief of a Victorian gentleman. He has lost his heir, his son. It is a terrible blow. But life must continue. The estate must be managed. The younger son, Alfred, is now the heir. But Roger's mother, Henriette Felicite Tichborne, born Henriette Felicite Seymour, reacts differently. She refuses to believe Roger is dead. Lady Tichborne is French. She was born in France, into an aristocratic French family, and married Sir James Tichborne in a match that united two old Catholic families. She is Roger's mother, and she loved her son with the fierce love that mothers have. When she is told Roger is dead, that the Bella sank, that there were no survivors, she does not accept it. No body was recovered. Roger's body was not found. How can they be sure he is dead? Perhaps he survived. Perhaps he was rescued. Perhaps he is alive somewhere, unable to get word home. This is not entirely irrational. Shipwrecks do occasionally have survivors. People are sometimes rescued by passing ships, are carried to distant ports, are delayed in getting home. It is unlikely, but not impossible, that Roger survived. Lady Tichborne clings to this hope. She refuses to wear mourning. She refuses to speak of Roger in the past tense. She insists that he is alive, that he will return, that they must not give up hope. Her family and friends are concerned. They try to comfort her, try to help her accept the reality of Roger's death. But she will not. Cannot. The grief is too much. The loss is too enormous. To accept that Roger is dead is to accept something unbearable, and so she does not accept it. Years pass. Sir James Tichborne dies in 1862, 8 years after Roger's presumed death. The title passes to Alfred, the younger son, who becomes Sir Alfred Tichborne, 11th baronet. Alfred inherits the estates, takes on the responsibilities that should have been Roger's. But Lady Tichborne still does not accept that Roger is dead. She is now the Dowager Lady Tichborne, living on the estate but no longer its mistress. She is in her 50s, a widow, her life shaped by loss, her husband dead, her eldest son dead, her position changed. But still, she believes Roger is alive. She begins to advertise. She places advertisements in newspapers, in England and abroad, seeking information about Roger Tichborne. She offers rewards for information leading to his discovery. She describes him: slight build, brown hair, educated in France, fluent in French, last seen boarding the Bella in 1854. The advertisements appear in newspapers in Australia, in South America, wherever English-speaking people might see them and might know something. Missing, Roger Tichborne. Reward for information. For years, nothing comes of these advertisements. No one responds with credible information. Roger remains lost, presumably dead, though his mother refuses to believe it. And then, in 1865, 11 years after the Bella sank, someone responds to the advertisements. Someone claims to be Roger Tichborne. In Australia, in a small town called Wagga Wagga in New South Wales, there lives a man who calls himself Tom Castro. Or sometimes Thomas Castro. The name varies. He is a butcher, or at least he works as a butcher, or perhaps he owns a butcher's shop. The details are unclear, will remain unclear, part of the general vagueness that surrounds this man. Tom Castro is not remarkable. He is a large man, heavy, weighing perhaps 20 stone, nearly 300 pounds. He has a round face, dark hair, unremarkable features. He speaks English with an accent that might be Australian or might be something else. He is illiterate, or nearly so. He works with his hands. He lives a simple life. This man, this Tom Castro, sees one of Lady Tichborne's advertisements, or someone shows it to him, or someone tells him about it. However the information reaches him, he learns that there is a woman in England seeking her lost son, that she believes this son survived the wreck of the Bella, that she is offering a reward for information. Tom Castro, after some thought, after perhaps some consultation with friends or advisors whose names we will learn later, decides to claim that he is Roger Tichborne. This seems absurd. Roger Tichborne was slight, thin, perhaps 8 or 9 stone, around 120 pounds. Tom Castro weighs 20 stone or more. Roger was educated, refined, fluent in French and English, comfortable in aristocratic society. Tom Castro is uneducated, rough, speaks no French. Roger had distinctive features, a particular appearance. Tom Castro looks nothing like the descriptions of Roger. But Tom Castro, or the people advising him, understand something about human psychology. Lady Tichborne desperately wants her son to be alive. She has wanted this for 11 years. People who want something desperately can convince themselves of almost anything. And 11 years is a long time. People change. Memories fade. Perhaps, just perhaps, Lady Tichborne can be convinced that this large butcher from Australia is her lost son. Tom Castro writes a letter. Or rather, someone writes a letter for him, since he can barely write himself. The letter is addressed to Lady Tichborne. It is written carefully, designed to awaken hope without making claims too specific or checkable. The letter says, approximately, "I am your son, Roger. I survived the wreck of the Bella. I have been living in Australia. I have been ill, have suffered hardships, which explain why I did not write sooner. I want to come home. Please send money for my passage. The letter includes some details meant to prove his identity. He mentions things about Tichborne House, about the family, things that Roger would know. Of course, these details are not secret. They could have been learned from various sources, from people who knew the family, from servants, from public records. But in the letter, they sound convincing. Lady Tichborne receives this letter in 1865. She reads it. And she believes it. Or perhaps believes is too strong a word. Perhaps she wants to believe it so desperately that she convinces herself to believe it. Perhaps she knows, on some level, that this cannot really be Roger, but the alternative, accepting that Roger is truly dead, is too painful, and so she chooses belief over doubt. She writes back. She sends money. She makes arrangements for Tom Castro to travel from Australia to England. She tells her family that Roger is alive, that he is coming home, that her faith has been justified. Her family is skeptical, deeply skeptical. Sir Alfred Tichborne, the current baronet, Roger's younger brother, does not believe this story. Neither do other family members. This is obviously a fraud, an impostor taking advantage of a grieving mother. But Lady Tichborne will not listen to their doubts. She knows her son. She will recognize him when she sees him. And he is coming home. In late 1866, Tom Castro, now calling himself Roger Tichborne, or the Claimant as he will become known in legal proceedings, arrives in England. He has travelled from Australia by ship, a journey of several months. Lady Tichborne has paid for his passage, has made all the arrangements. The Claimant is met at the port by representatives of Lady Tichborne. They see a large, heavy man, dressed simply, speaking with an odd accent, appearing nothing like the descriptions they have of Roger Tichborne. They are immediately suspicious. But orders are orders. They escort the Claimant to where Lady Tichborne is staying, not at Tichborne House, which is now Alfred's, but at a hotel in London. The meeting between Lady Tichborne and the Claimant is arranged carefully. It takes place in a darkened room. Lady Tichborne's eyesight is poor. She is in her 60s now, and her vision has deteriorated. The lighting is dim. The Claimant enters the room. Lady Tichborne rises to greet him. She looks at him, peers at him in the dim light, and then she says the words that will shape everything that follows. He is my son. I know my son. This is Roger. She embraces him. She weeps. She is overcome with emotion. Her son, lost for so long, has returned. The miracle she believed in has occurred. The family members present are stunned. How can she recognize this man? He looks nothing like Roger. He is enormous where Roger was slight. He shows no sign of Roger's education, Roger's refinement. He speaks no French, though Roger was fluent. But Lady Tichborne is certain. She knows her son, and she will support his claim with all her resources, all her influence, all her determination. The Claimant is installed in lodgings. Lady Tichborne provides him with money, with clothes, with everything he needs. She introduces him to people as her son, as Roger Tichborne. Some people, out of politeness or confusion, go along with this. Others are openly skeptical. The Claimant begins to tell his story, the story of how he survived the wreck of the Bella, how he came to be in Australia, why he did not contact his family sooner. The story changes in the telling. Details shift. But the core remains: he is Roger Tichborne, he survived, he has returned. Sir Alfred Tichborne, the current baronet, is not convinced. Neither are most other family members. They see an obvious impostor, a fraud. But how to prove it? Lady Tichborne believes in him, or claims to. She has influential friends. The claimant is creating supporters, people who believe his story or who have reasons to support him. This will not be settled quietly. This will require the law, require courts, require a trial. And so begins what will become one of the longest, most expensive, most sensational trials in English legal history. The legal proceedings begin as a civil case. The claimant, for that is what he is called in the legal documents, the claimant files suit to recover the Tichborne estates. He asserts that he is Roger Charles Doughty Tichborne, the rightful heir, and that the estate should be his, not Alfred's. Sir Alfred Tichborne and the other defendants respond that the claimant is not Roger, that Roger died in 1854, that this is a fraud. They will prove it in court. The case is titled Tichborne v. Lushington, though it will be known to the public as the Tichborne Case. It begins in May 1871, 17 years after the Bella sank, 5 years after the claimant arrived in England. The trial takes place in Westminster Hall, a medieval building that has housed courts for centuries. The courtroom is packed every day with spectators. The case has captured public imagination. Is this really Roger Tichborne, miraculously returned? Or is he an impostor, one of the most audacious frauds in history? People want to know. Newspapers cover the trial daily. The whole nation is watching. The judge is Sir William Bovill, Chief Justice of Common Pleas. He is experienced, careful, patient. He will need all his patience for this trial. The claimant is represented by a team of lawyers led by a barrister named Sergeant Ballantyne. Ballantyne is skilled, forceful, a fighter. He believes in his client, or at least argues as if he does. The defendants, Sir Alfred and the family, are represented by another team led by Sir John Coleridge, Solicitor General. Coleridge is brilliant, meticulous, devastating in cross-examination. He does not believe the claimant for a moment, and he will prove it. The trial begins with opening statements. Sergeant Ballantyne rises to present the claimant's case. He tells the story: Roger Tichborne boarded the Bella, the ship sank, but Roger survived. He was rescued by a ship that took him to Australia. Suffering from injuries and memory problems, he lived for years without revealing his identity. Eventually, he saw his mother's advertisements and came forward. Why did he change so much physically? Years of hard labor in Australia, poor diet, illness, these explain his weight gain. Why does he not speak French? The trauma of the shipwreck, the years of disuse, he has forgotten. Why does he not remember many details of his youth? Memory is fallible, especially after trauma. Ballantyne's opening is effective. He anticipates the objections, provides explanations. Some of these explanations are thin, but they are explanations. And he has Lady Tichborne on his side, a mother who has recognized her son. Surely a mother would know her own child? Sir John Coleridge, for the defendants, is brief in his opening. The case is simple, he says. This man is not Roger Tichborne. Roger Tichborne died in 1854 when the Bella sank. This man is an impostor. The defendants will prove it with evidence, documentary evidence, witness testimony, physical evidence. The truth will emerge. And so the trial proper begins. The evidence phase. The witnesses. The cross-examinations. The slow, grinding process of establishing facts, testing stories, building a case. This phase will last not days, not weeks, but months. Nearly a year. The longest civil trial in English history up to that point. Let us slow down and examine some of this testimony in detail. For it is in the details that the case will be won or lost. And it is in the details that we find the perfect material for our purposes, the repetitive, technical, mind-numbingly thorough examination of minutiae that makes for excellent sleep content. One of the first major points of contention is a tattoo. Roger Tichborne, according to several witnesses, had a tattoo on his left arm. The tattoo depicted certain letters or symbols. The witnesses differ on the exact design, but they agree a tattoo existed. The claimant has no such tattoo. His left arm is unmarked. This seems like strong evidence that he is not Roger. How can he be Roger if he lacks a distinctive mark that Roger had? Sergeant Ballantyne, cross-examining the witnesses who mention the tattoo, tries to shake their testimony. Are they certain about the tattoo? Could they be misremembering? Roger was young when they last saw him. Perhaps the tattoo came later? Or perhaps they are confusing Roger with someone else. One witness is pressed for days about the tattoo. Did he see it personally? Yes. When? Where? In what circumstances? Describe it precisely. What did it look like? What color was the ink? How large was it? Where exactly on the arm was it located? The witness does his best to answer. He saw the tattoo many years ago. His memory of the exact details is imperfect. He knows there was a tattoo, is certain of that, but the precise details, it was a long time ago. Ballantyne seizes on this uncertainty. If the witness cannot remember the exact details, can we really trust his memory that there was a tattoo at all? Perhaps he is misremembering. Perhaps the tattoo was on someone else. Perhaps it never existed. But there are multiple witnesses who remember the tattoo. They cannot all be wrong. And the claimant definitely has no tattoo. His arm was examined by doctors. The skin is unmarked. If he ever had a tattoo, it has been removed somehow, but there is no scarring to suggest removal. The claimant's explanation is vague. Perhaps the witnesses are mistaken. Perhaps Roger never had a tattoo. Or perhaps the tattoo was temporary somehow, faded away. The explanation satisfies no one, but without the tattoo present on the claimant's arm, it cannot be conclusively proven whether Roger had one or not. Days of testimony. Days of cross-examination. All about a tattoo. Whether it existed. What it looked like. Whether its absence proves the claimant is not Roger. The testimony is tedious, repetitive. The same questions asked in slightly different ways. The same answers given with slight variations. The lawyers probing, looking for inconsistencies, for weaknesses. The judge listening patiently, taking notes, occasionally asking clarifying questions. The courtroom grows warm with all the people crowded in. The afternoon sun slants through the windows. The lawyers' voices drone on. The witnesses answer, sometimes confidently, sometimes hesitantly. The court reporter writes everything down, his pen scratching steadily across page after page. And slowly, gradually, the testimony about the tattoo concludes. No definitive answer has been reached. The matter is unclear. The trial moves on to other evidence. Another major line of inquiry concerns the claimant's memories of Roger Tichborne's childhood. If he is really Roger, he should remember events from his youth, places he visited, people he knew. His memory should align with the documented facts of Roger's life. The claimant is questioned extensively about his childhood. Where did you live? Who were your tutors? What games did you play? What rooms were in Tichborne House? Describe the grounds. Who were your friends? What did you do on holidays? The claimant answers, but his answers are often vague or incorrect. He misidentifies rooms in Tichborne House. He cannot name tutors that Roger definitely had. He describes events that did not happen or happened differently than he claims. Sometimes his answers are suspiciously accurate, matching details that could have been learned from other sources. But other times, when asked about things that only Roger would know, he cannot answer or answers incorrectly. The questioning goes on for days. The claimant sits in the witness box, a large man in clothes that fit awkwardly, answering questions put to him by Sir John Coleridge and the other defense lawyers. Do you remember the wallpaper in the drawing room at Tichborne House? Describe it. The claimant describes wallpaper, but witnesses testify it does not match the actual wallpaper. Do you remember your mother's sitting room? Where was it located? The claimant places it on the second floor. Witnesses testify it was on the ground floor. Do you remember Christmas celebrations? What traditions did the family observe? The claimant describes certain traditions. Some match the Tichborne family's practices. Others do not. Do you remember your education in France? Where were you a student? The claimant names a school. Records show Roger attended a different school. On and on the questions go. Each answer is checked against documentary evidence or witness testimony. Each discrepancy is noted, recorded, will be used in final arguments. The claimant becomes flustered, frustrated. He claims that his memory is poor, that the trauma of the shipwreck affected his memory, that the passage of so many years has dimmed his recollections. Sometimes this explanation seems plausible. Other times it seems like an excuse for ignorance. The cross-examination of the claimant becomes legendary. It lasts not hours, not days, but weeks. 22 days. The longest cross-examination in English legal history to that point. Sir John Coleridge is relentless. He has prepared meticulously. He has every document, every fact about Roger Tichborne's life at his fingertips. He knows more about Roger Tichborne than the claimant does. And he uses this knowledge to devastating effect. Question after question. Detail after detail. The claimant struggles. Sometimes he answers. Sometimes he says he does not remember. Sometimes he contradicts himself, giving different answers to the same question asked at different times. The spectators watch, fascinated. The newspapers report every day's testimony. People take sides, some believe the claimant, sympathize with him, think the lawyers are being unfair. Others see a fraud being exposed, slowly but surely. One of the most damaging aspects of the case for the claimant is the question of language. Roger Tichborne was fluent in French. He was educated in France. He corresponded in French. French was, in many ways, his primary language. The claimant speaks no French. None. Not a word. When asked to speak French, the claimant cannot. When French letters that Roger wrote are shown to him and he is asked to read them aloud, he cannot. When asked simple questions in French, he does not understand them. How can this be explained? How can Roger Tichborne, for whom French was a native language, have completely forgotten it? The claimant's lawyers argue that trauma can affect language. That years of disuse can cause a language to be forgotten. That the claimant's brain injuries from the shipwreck explain his linguistic deficits. Medical experts are called. They testify about brain injuries, about aphasia, about memory loss. Some experts say it is theoretically possible for someone to forget a language after severe trauma. Others say that while vocabulary might be forgotten, the underlying ability to understand and produce the language would remain. A native French speaker might be rusty after years without practice, but would not be completely unable to understand French. The claimant is tested in court. Simple French phrases are spoken to him.
Comment allez-vous?
How are you? He shows no sign of comprehension.
Quel est votre nom?
What is your name? No response.
Parlez-vous français?
Do you speak French? Nothing. The demonstration is devastating. The courtroom sees clearly that this man has no knowledge of French whatsoever. And yet Roger Tichborne was fluent. More witnesses are called. People who knew Roger in France. They testify about his facility with the language, about how he spoke French naturally, without hesitation, without accent. They describe conversations they had with Roger in French, letters he wrote in French. The claimant sits and listens to this testimony through interpreters. He cannot understand it himself because much of it is in French, illustrating the very point being made. The defense drives the point home relentlessly. Day after day, they return to the question of language. They produce more letters in Roger's handwriting, in French. They call more witnesses who spoke French with Roger. They show that French was not merely a language Roger studied but a language he lived in, thought in, dreamed in. And the claimant cannot speak a word of it. The explanation offered, trauma, memory loss, brain injury, seems increasingly inadequate. Forgetting vocabulary is one thing. Forgetting an entire language, especially one's native language, is something else entirely. The trial also examines in excruciating detail the physical differences between Roger Tichborne and the claimant. Roger Tichborne, according to various witnesses and records, was approximately 5 feet 9 inches tall, perhaps 5 feet 10. He weighed approximately 8 to 9 stone, around 112 to 126 pounds. He was slight, thin, perhaps even delicate in build. The claimant is approximately 5 feet 9 inches tall, so the height matches, more or less. But he weighs 20 stone or more, close to 300 pounds. He is massively heavy, stout, with a large belly, thick arms, a round face. How can someone gain so much weight? The claimant's lawyers argue that years of different diet in Australia, years of physical labor followed by more sedentary work, the natural weight gain that comes with age, all these factors combine to transform Roger's slight frame into the claimant's massive one. Medical experts testify about weight gain, about how much weight a person can realistically gain over 15 years or so. Some experts say that a gain of this magnitude is medically possible, though unusual. Others say it strains credulity. But the differences are not only in weight. The bone structure seems different. Roger had fine bones, delicate features. The claimant has heavy bones, coarse features. Can bone structure change with weight gain? The experts debate this. the testimony becomes highly technical, involving discussions of skeletal anatomy, of how bones grow and change with age, of how overlying tissue can change the apparent shape of bones. Measurements are taken of the claimant, his head circumference, the length of his arms, the size of his hands and feet. These measurements are compared to descriptions of Roger's physical dimensions, where such descriptions exist. Some measurements seem compatible with Roger having grown into the claimant. Others seem incompatible. The expert witnesses disagree about which measurements are significant and which are not. Days of testimony about bone structure, about anthropometry, about physical development. The courtroom listens to detailed discussions of femur length, skull shape, the distance between specific anatomical landmarks. Photographs of Roger Tichborne as a young man are produced. The courtroom examines them, comparing the face in the photographs to the claimant's face. Some people think they see a resemblance. Others see two completely different people. The claimant's face is also examined for specific features. Roger had a particular scar, witnesses say, from a childhood accident. The claimant is asked about this scar. He provides an explanation for how Roger received it, but the explanation differs from what other witnesses remember. And when doctors examine the claimant's face, they cannot find the scar where it should be. The eyes are another point of contention. Multiple witnesses remember that Roger Tichborne had blue eyes. The claimant has brown eyes. Or perhaps hazel. Or perhaps a darker shade that could be described as brown or hazel depending on the light. Can eye color change? The lawyers debate this. Generally not, the medical experts agree. Eye color is established in infancy and remains constant throughout life. Brown eyes do not become blue. Blue eyes do not become brown. But lighting conditions can affect perception of eye color, the claimant's lawyers argue. Perhaps the witnesses misremembered. Perhaps Roger's eyes were actually hazel or brown and people misremembered them as blue. Memory is fallible, especially regarding details like eye color observed years in the past. More witnesses are called. They are asked, what color were Roger Tichborne's eyes? Blue, they say. Definitely blue. They are certain. They remember clearly. The claimant's eyes are examined in court. In the bright light of the courtroom. In dimmer light. From different angles. What color are they? The observers disagree somewhat. Brown, some say. Hazel, others say. Greenish-brown. Dark but not quite brown. But no one looking at the claimant's eyes describes them as blue. Days are spent on this question. Witnesses testifying about eye color. Doctors discussing the physiology of eye color. Lawyers arguing about what the evidence proves. The cumulative effect of all these physical differences, the weight, the features, the missing scar, the eye color, is powerful. Each difference alone might be explained away. But together, they create a compelling picture of a man who is simply not Roger Tichborne. Yet the claimant persists in his claim. And Lady Tichborne continues to support him, continues to insist that he is her son. How can a mother be wrong about her own child? Lady Tichborne is called to testify. The courtroom is hushed when she takes the witness stand. Here is the woman at the center of this drama, the grieving mother who refused to accept her son's death, who believed in his survival, who recognized this man as her lost child. She is now in her late 60s, elderly by Victorian standards. Her eyesight is poor. She speaks with a French accent, her English still imperfect after decades in England. She is dignified, determined, convinced. Sergeant Ballantyne, representing the claimant, questions her gently. Lady Tichborne, when did you first see the claimant? In late 1866, she answers, in London. How did the meeting occur? In a darkened room, she explains. Her eyesight was poor, the light was dim. And you recognized him as your son? Yes, immediately. How? By a mother's intuition, by certain features, by the way he moved, by something indefinable that only a mother would know. Did you have any doubts? None. This is my son. I know my own child. Ballantyne leads her through her reasons for believing. She mentions small details, things the claimant said that only Roger would know, mannerisms that reminded her of Roger, a general sense of familiarity. The testimony is emotional, heartfelt. But then Sir John Coleridge rises to cross-examine. He is respectful. One must be respectful to an elderly lady, especially one of aristocratic rank, but he is also thorough. Lady Tichborne, your eyesight is poor, is it not? Yes, she admits. You have trouble seeing clearly? Yes. The room was darkened when you first met the claimant? Yes. So you did not see him clearly? I saw enough, she insists. Coleridge presses gently but firmly. You want to believe your son is alive, do you not? Of course, she says. You have wanted to believe this for many years? Yes. Might this desire have affected your judgment? No, she is certain. This is her son. Coleridge asks about specific features. Roger was slight. The claimant is very heavy. How do you explain this? People change, she says. Many years have passed. Roger was young when last she saw him. People gain weight as they age. Roger spoke French fluently. The claimant speaks no French. How do you explain this? Lady Tichborne hesitates. She does not have a good answer. Perhaps he has forgotten. Perhaps the trauma. Her voice trails off. She knows this is weak. Coleridge does not press too hard. He has made his point. The cross-examination concludes. Lady Tichborne steps down from the witness stand. She has testified to her belief, but Coleridge has shown the jury how that belief might be the result of desire rather than reality. The testimony regarding Lady Tichborne's recognition occupies days of the trial. Other witnesses are called who were present at that first meeting, who observed Lady Tichborne's reaction, who have opinions about whether her recognition was genuine or the product of wishful thinking. Psychologists testify. Though the term psychologist is not yet common, they are called alienists or medical men with expertise in disorders of the mind. They discuss how grief can affect perception, how a strong desire to believe something can lead a person to interpret ambiguous evidence in favor of that belief. Can a mother be fooled about her own child? The experts debate. Generally not, some say. The maternal bond is strong, the recognition deep and instinctive. But in cases of extreme grief, when the mother desperately wants the person to be her child, mistakes can occur, others argue. The testimony is technical, slow, repetitive. The same questions asked of different experts. The same theories explained in slightly different ways. The jury listens, takes notes, tries to make sense of conflicting expert opinions. The trial also delves deeply into genealogy, into family trees, into the question of who would inherit the Tichborne estates if Roger were truly dead. This becomes important because the defendants argue that the claimant has a motive to impersonate Roger, the motive of inheriting vast wealth. If Roger is dead, the estates go to Alfred. But if someone can convince the world he is Roger, that person becomes immensely rich. The lawyers present detailed genealogical charts. The Tichborne family tree is drawn out, going back generations. Every branch is examined. Every potential heir is identified. If Roger died in 1854, the heir was Alfred. Alfred is now the 11th baronet, has been for nearly a decade. He has children of his own, who are next in line after him. But if Roger lived, if the claimant is Roger, then Alfred's claim is void. The estates revert to Roger, to the claimant. Alfred loses everything. Alfred's children lose their inheritance. The financial stakes are explained to the jury. The Tichborne estates generate income of approximately £5,000 per year, a vast sum in the 1870s, equivalent to perhaps £500,000 or more per year in modern terms. Plus the land itself is valuable, worth hundreds of thousands of pounds. This is what the claimant stands to gain if his claim is accepted. This is why someone might be willing to undertake such a fraud. But who is the claimant if he is not Roger? The defendants must prove not only that he is not Roger but also who he actually is. If they can show he is someone else, someone with a documented identity that conflicts with being Roger, the case is strengthened immensely. The investigation into the claimant's true identity becomes a major focus. Detectives are hired. They trace his movements before he appeared in Australia. They search for records, for witnesses who knew him under a different name. And eventually, they find evidence. The claimant, they discover, is actually a man named Arthur Orton. Orton was born in Wapping, a rough district of London, in 1834. He was the son of a butcher. He grew up poor, had little education, worked as a butcher's apprentice. In his youth, Orton got into trouble. He was accused of theft, perhaps other crimes. To escape prosecution or simply to seek opportunity, he left England and went to sea. He worked on ships, traveled to South America, eventually ended up in Australia. In Australia, Orton worked as a butcher, using the name Tom Castro or Thomas Castro. He married a woman there, had children, lived an unremarkable life. This is the man, the defendants argue, who is claiming to be Roger Tichborne. Not a shipwreck survivor, not an amnesiac aristocrat, but Arthur Orton, butcher's son from Wapping, impersonating a dead man for money. The evidence for this identification is substantial. Witnesses who knew Arthur Orton are brought to court. They look at the claimant and identify him. Yes, that's Arthur Orton, they say. I knew him as a boy in Wapping. Or, I knew him in Australia as Tom Castro. That's the same man. Some of these witnesses are compelling. They describe specific incidents, specific conversations, details that seem to prove they really did know the claimant under another name. Other witnesses are less credible. They admit they have not seen Orton in many years, that their memory is imperfect, that the claimant is much heavier now than Orton was then. But they still believe it is the same man. The claimant denies being Arthur Orton. He has never heard of this person, he claims. These witnesses are mistaken or lying. He is Roger Tichborne, not Arthur Orton. But the evidence accumulates. Records from Wapping show an Arthur Orton born in 1834. Records from ships show an Arthur Orton working as a sailor. Records from Australia show a Tom Castro who arrived in the colony at approximately the time Arthur Orton disappeared from the shipping records. Handwriting analysis is performed. Documents written by Arthur Orton before he left England are compared to documents written by the claimant. The handwriting appears similar, though the analysis is not definitive. Handwriting expertise is still primitive in the 1870s. Photographs of Arthur Orton as a young man, if they exist, are produced and compared to the claimant. The comparison is difficult because Orton was much younger and thinner in any such photographs, but some observers think they see a resemblance. This line of evidence, proving the claimant is actually Arthur Orton, occupies weeks of the trial. Witness after witness. Document after document. The slow accumulation of details that, taken together, create a compelling case that the claimant is not who he says he is. Another significant area of examination is handwriting. Roger Tichborne wrote many letters during his life. These letters survive, letters to his family, to friends, business correspondence, personal notes. The handwriting in these letters is distinctively Roger's. The claimant, when he arrived in England, also wrote letters. Not many, his literacy is limited, but some. And these letters are in a different handwriting from Roger's letters. The difference is shown to the jury. Roger's handwriting is educated, flowing, formed by years of careful instruction. The letters are well-shaped, the spelling is correct, the grammar is proper. The claimant's handwriting is crude, barely literate. The letters are poorly formed. The spelling is atrocious, basic words misspelled, phonetic spellings, errors that an educated person would never make. The grammar is poor. Expert witnesses on handwriting are called. They examine the documents. They testify that the handwriting is different, that Roger's educated hand and the claimant's crude hand could not be from the same person. But the claimant's lawyers argue that handwriting can change. The claimant suffered injuries in the shipwreck, they say. Perhaps his hand was injured, affecting his ability to write. Years of manual labor in Australia, wielding a butcher's knife, might have coarsened his hand, changed his grip on a pen. And if he lost his education through amnesia, if he forgot French, might he not also have forgotten proper spelling and grammar? Might his handwriting have deteriorated along with his other educated accomplishments? The experts debate this. Some say handwriting is so deeply ingrained that it cannot be entirely forgotten or changed. The basic structure of how a person forms letters, the characteristic patterns, these persist even if the overall quality deteriorates. Others say that severe trauma can affect handwriting, that relearning to write after a brain injury might result in a completely different hand. The jury is shown document after document. Letters Roger wrote in French from France. Letters he wrote in English from Chile. A few personal notes in his handwriting. Then letters written by the claimant, with their poor spelling and crude formation. The contrast is stark. Whatever the argument about brain injury and deterioration, the simple visual comparison is damaging to the claimant's case. This evidence, like all the other evidence, is presented slowly, carefully, thoroughly. Each document must be authenticated, proved to be genuine, not a forgery. Each expert must explain their qualifications, their methodology, their conclusions. Each piece of testimony is subject to cross-examination, to challenge, to endless lawyerly probing. Days pass. Weeks pass. The trial grinds on. By early 1872, the civil trial has been going on for nearly a year. Hundreds of witnesses have testified. Thousands of pages of documents have been entered into evidence. The costs have mounted into tens of thousands of pounds. And the claimant's case is collapsing. The accumulated weight of evidence against him has become overwhelming. The physical differences, the language issue, the handwriting, the witnesses who identify him as Arthur Orton, the inability to remember details of Roger's life that should be unforgettable. Against all this, the claimant has only Lady Tichborne's recognition and his own insistence that he is Roger. It is not enough. In March 1872, the claimant's lawyers make a decision. They withdraw from the case. They announce in court that they can no longer in good conscience represent the claimant, that the evidence has convinced them he is not who he claims to be. This is devastating. For lawyers to abandon their client in the middle of a trial is extremely rare. It signals complete loss of faith in the case. The claimant is left without representation. The judge offers to appoint new lawyers for him, but the damage is done. The case is over. The jury does not even need to reach a verdict. The claimant's own lawyers have effectively conceded defeat. The civil trial ends. The claimant is not Roger Tichborne. The estates remain with Sir Alfred. Lady Tichborne's recognition has been rejected. The claimant's claim has failed. But the story is not over. Because during the trial, evidence has emerged that the claimant is not merely mistaken about his identity. He is not a deluded man who genuinely believes he is Roger. He is a fraud, a con artist, deliberately impersonating a dead man for financial gain. And fraud of this magnitude is a crime. The claimant will now face criminal prosecution. In 1873, the claimant is arrested and charged with perjury. The charge is that he deliberately lied under oath when he testified in the civil trial that he was Roger Tichborne. If convicted, he could face years in prison. The case is now titled Regina versus Castro, the Queen against Castro, using one of the names the claimant used in Australia. But everyone still calls it the Tichborne case. A new trial begins. This time, the burden of proof is on the prosecution. They must prove beyond reasonable doubt that the claimant is not Roger Tichborne and that he knew he was not Roger when he made his claim. Much of the evidence from the civil trial is repeated. The same witnesses testify again. The same documents are produced again. The same arguments are made again. But this time, the trial focuses more on proving that the claimant is Arthur Orton and that he deliberately perpetrated a fraud. The prosecution presents evidence of the claimant's movements before he appeared in Australia claiming to be Roger. They trace Arthur Orton's life, his birth in Wapping in 1834, his youth as a butcher's apprentice, his departure from England, his time at sea, his arrival in Australia. They show that Arthur Orton arrived in Australia around the same time that Tom Castro appeared there. That Tom Castro worked as a butcher, as Arthur Orton had been trained to do. That Castro had no documented existence before a certain date, the same date that Orton arrived in the colony. They bring Orton's family members to testify. Arthur Orton's mother, elderly now, is brought to court. She looks at the claimant. "That is my son," she says. "That is Arthur." She weeps. She does not understand why he is claiming to be someone else, why he will not acknowledge his own mother. The claimant denies this. He has never seen this woman before. She is not his mother. He is not Arthur Orton. But the woman provides details. She describes Arthur as a child, his personality, his habits, events from his youth. Some of these details match things known about the claimant. She describes a scar Arthur had, and the claimant has a similar scar in the same location. The prosecution also examines the claimant's associates, the people who helped him prepare his claim, who coached him, who may have provided him with information about the Tichborne family. One key figure is a man named Bogle, who was involved with the claimant in Australia. Bogle, the evidence suggests, helped research the Tichborne family, gathered information from newspapers and other sources, briefed the claimant on what to say. Did Bogle and others actively create the fraud? Or did the claimant deceive them too, convincing them he really was Roger? The evidence is unclear, but it suggests a conspiracy, a planned fraud rather than a delusion. The criminal trial is even longer than the civil trial. It begins in April 1873 and does not conclude until February 1874. Nearly a year of testimony, of cross-examination, of legal argument. The courtroom remains packed throughout. Public interest has not waned. If anything, it has increased. This is now not just a civil dispute about property but a criminal case about fraud and deception. The newspapers continue their daily coverage. People follow the case avidly. There are those who still believe in the claimant, who think he is being persecuted, that the evidence against him is fabricated by the Tichborne family to protect their wealth. But most have turned against him. The weight of evidence is too great. In February 1874, after nearly a year of trial, the case goes to the jury. The jury deliberates. They do not take long. The evidence is overwhelming. The verdict: guilty. The claimant is guilty of perjury. The judge, in sentencing, is severe. This was a calculated fraud, he says. The claimant deliberately attempted to steal an estate, to defraud the rightful heirs, to deceive the courts. He took advantage of a grieving mother's hopes. He lied repeatedly under oath. This is a serious crime deserving serious punishment. The sentence: 14 years of penal servitude. Hard labor. A harsh sentence, but considered appropriate for the magnitude of the fraud. The claimant is taken to prison. He will spend the next 14 years, or most of them, if he receives any reduction for good behavior, doing hard labor in a Victorian prison. Lady Tichborne does not attend the verdict. She is too ill, too old, too heartbroken. She continues to believe, or claims to believe, that the claimant is her son, that he has been wrongly convicted. She dies in 1868, before the criminal trial even begins. Wait, no, that chronology is wrong. Let me correct, she dies in 1868, actually before the civil trial concludes. Her death occurs during the long litigation. Actually, checking the historical record more carefully, Lady Tichborne died in March 1868, which was before the trials we are describing. She provided a deathbed statement supporting the claimant's claim, but she did not live to see the trial's conclusions. Her death removes the claimant's most important supporter. Without her, his case becomes even weaker. Her recognition of him was the emotional core of his claim. With her gone, he is just a large, uneducated man with an implausible story and mounting evidence against him. The claimant serves his sentence. The years pass slowly in prison. Hard labor. Poor conditions. The company of criminals. A far cry from the life of a wealthy baronet that he tried to claim. He is released in 1884. After serving 10 years, his sentence reduced somewhat for good behavior. He emerges from prison aged 50, broken in health, his fraud exposed, his name a byword for imposture. What does he do with the rest of his life? He tries to earn money from his notoriety. He gives lectures, telling his story, though now, perhaps, admitting the truth, or perhaps still maintaining the fiction. He publishes pamphlets. He appears at fairs and exhibitions as a curiosity. The money he earns is not much. He lives in poverty. The man who tried to claim millions' lives on pennies. In 1898, Arthur Orton, for that is who he was, he dies. He is 64 years old. He has spent his last years in obscurity and poverty. But even in death, there is a final twist. His coffin bears a nameplate, and the name on it is Sir Roger Charles Doughty Tichborne. To the very end, he maintained his claim. Or perhaps those who buried him, supporters who still believed, insisted on that name. Either way, the man who was not Roger Tichborne was buried as if he were. The Tichborne case raises profound questions about identity. What makes someone who they are? Is it physical appearance? Memory? Language? Some ineffable essence? Roger Tichborne was a real person with a specific identity, his body, his memories, his education, his family relationships. These things made him Roger Tichborne. The claimant had none of these things. He looked different. He remembered differently. He spoke differently. He was, in every objective way, not Roger. Yet Lady Tichborne believed he was. A mother recognized her son. Or thought she did. Or wanted so desperately to believe she did that she convinced herself. The case shows the power of hope and denial. Lady Tichborne could not accept her son's death. The pain was too great. And so when someone appeared claiming to be Roger, she seized on it. She found reasons to believe. She ignored or explained away the contradictions. This is human. We all do this to some degree, believe what we want to believe, see what we want to see. Lady Tichborne's delusion was extreme, but it was an extreme version of a universal human tendency. The case also shows how identity can be constructed and performed. The claimant learned things about Roger Tichborne. He learned enough to be somewhat convincing, at least initially. He performed the role of Roger, imperfectly but well enough to fool some people. In our modern world, we might think of identity theft, of people assuming others' identities online, of the ease with which identity can be faked. The Tichborne case is a 19th-century version of these modern crimes. The case also reveals something about memory and its fallibility. Many witnesses testified about Roger Tichborne, what he looked like, how he behaved, specific events from his life. But witnesses disagreed. Memories varied. Details that should have been certain were disputed. This is natural. Memory is not a recording. It is a reconstruction. Each time we remember something, we rebuild it from fragments, and those fragments can be influenced by subsequent experiences, by suggestions, by our desires and beliefs. The Tichborne case is a study in the unreliability of memory, the malleability of identity, the power of hope and grief. The Tichborne case had significant impacts on English law and legal procedure. First, it demonstrated the need for better identity documentation. In the 1850s and 1860s, proving who you were was difficult. There were no photographs on identity cards, no fingerprinting, no DNA testing. Identity was proved through witnesses, through documents like baptismal certificates, through circumstantial evidence. The Tichborne case showed how inadequate these methods could be. After the case, there was increased interest in developing better systems for establishing and verifying identity. Second, the case highlighted issues with the length and cost of litigation. The combined civil and criminal trials lasted over 3 years. The costs ran to hundreds of thousands of pounds. This was clearly inefficient and unjust. Legal reforms in the late Victorian period and early 20th century tried to address these problems, making trials more efficient, limiting the length of cross-examination, streamlining procedures. Third, the case became a landmark in the law of evidence, particularly regarding expert testimony. The trials featured extensive expert testimony, medical experts, handwriting experts, language experts. The courts had to grapple with how to evaluate such testimony, how much weight to give it, how to handle conflicting expert opinions. The principles developed in the Tichborne case influenced how expert evidence was treated in subsequent cases. Fourth, the case became famous as an example of cross-examination technique. Sir John Coleridge's 22-day cross-examination of the claimant was studied by lawyers for generations. It demonstrated how patient, methodical questioning could dismantle a false story, could expose inconsistencies, could ultimately reveal the truth. Law students read about the Tichborne case as an example of effective advocacy, of how a skilled barrister can use the tools of cross-examination to devastating effect. Fifth, the case affected public attitudes toward the legal system. The excessive length, the enormous cost, the spectacle of the trials, all these led to criticism of how justice was administered. The case contributed to pressure for legal reform. In these ways, the Tichborne case, though ultimately about one man's fraudulent claim, had impacts that extended far beyond the immediate parties, influencing legal development and public understanding of the law. Throughout the trials and for years afterward, the Tichborne case fascinated the British public. Why did this case capture imagination so completely? Part of the answer lies in the dramatic story. A shipwreck. A lost heir. A grieving mother. A mysterious return. The possibility that a man could lose his identity and then reclaim it. These are the elements of romance, of adventure stories, of the novels that Victorians loved to read. The case had a strong class element too. Roger Tichborne was an aristocrat. Arthur Orton was working class. The idea that a butcher's son could successfully impersonate a baronet, even temporarily, was both thrilling and threatening to Victorian social order. For working-class observers, there was perhaps some satisfaction in seeing an ordinary man challenge the aristocracy, even if ultimately unsuccessfully. For upper-class observers, there was horror at the thought that birth and breeding could be so easily faked. The case also tapped into Victorian anxieties about identity and authenticity. This was an era of rapid social change. People were moving from countryside to cities. Traditional social structures were weakening. It was becoming easier to reinvent oneself, to claim a different identity. The Tichborne case was an extreme example of this, a complete identity change, but it reflected broader social anxieties about knowing who people really were. The trials themselves were entertainment. In an era before television or radio, before movies, public trials were a form of spectacle. People crowded into courtrooms to watch. They followed the proceedings in newspapers. They debated the case in pubs and drawing rooms. The Tichborne case, with its length and complexity, provided years of entertainment. There were dramatic moments, Lady Tichborne's testimony, the revelation that the claimant couldn't speak French, the identification of him as Arthur Orton. There were long stretches of technical testimony that were tedious but somehow still compelling. People took sides. There were Tichborneites who believed in the claimant, who thought he was genuinely Roger or at least deserved the benefit of the doubt. There were anti-Tichborneites who saw an obvious fraud. The debate continued even after the verdict. Some Tichbornites never accepted that the claimant was Arthur Orton. They believed he was Roger, that he had been wrongly convicted, that the Tichborne family had used their wealth and influence to pervert justice. This belief persisted for years, even decades. There were Tichborne societies dedicated to clearing the claimant's name. There were pamphlets and books arguing for his innocence. The case became a cause, a grievance, a story that would not die. As the 19th century turned into the 20th, the Tichborne case gradually faded from public consciousness. The principals died, the claimant in 1898, Sir Alfred Tichborne in 1891, all the lawyers and judges and key witnesses eventually passing away. New scandals, new sensations took the public's attention. The Tichborne case became history, a Victorian curiosity, a story from an earlier era. But it was not forgotten entirely. The case appeared in legal textbooks as a landmark case. It was taught in law schools. Historians studied it as a window into Victorian society, Victorian law, Victorian psychology. The case also inspired fiction. Writers used it as the basis for novels and plays. The themes, imposture, identity, the power of grief, proved durable and compelling. In the 20th century, there were occasional revivals of interest. Books were published re-examining the case. Was the verdict correct? Was the claimant really Arthur Orton? Or was there, perhaps, some possibility that he was Roger Tichborne after all, that the evidence against him was less conclusive than it seemed? Most historians and legal scholars concluded that the verdict was correct, that the claimant was indeed Arthur Orton, that the fraud was real. But a few contrarians continued to argue the other side, to suggest that perhaps, just perhaps, Lady Tichborne was right to recognize her son. These debates, though they attracted some attention, never changed the fundamental historical verdict. The Tichborne claimant was Arthur Orton, butcher's son from Wapping, who tried and failed to steal an aristocratic identity. The case remains important as a historical curiosity, as a legal landmark, as a story that reveals something about human nature, about grief and hope, about identity and deception, about the complexities of truth and evidence. Let us slow down now, as we approach the end of our journey through the Tichborne case. Let us reflect on the nature of this case, on what it means, on why we have spent these hours exploring it in such detail. The Tichborne case is, in one sense, simple. A man claimed to be someone he was not. He was exposed and punished. The end. But in another sense, the case is infinitely complex. Every detail branches into more details. Every question answered raises more questions. The evidence is vast, overwhelming, impossible to fully master. Consider just the question of the tattoo. Did Roger Tichborne have a tattoo? Some witnesses said yes. The claimant had no tattoo. Therefore, the claimant is not Roger. But which witnesses? What did they remember? How certain were they? What did the tattoo look like? When did Roger get it? Why did he get it? What happened to it if the claimant is Roger? Each question branches. Each witness must be evaluated. Each piece of testimony must be weighed against other testimony, against physical evidence, against inherent probabilities. And the tattoo is just one small piece of the case. There are hundreds of such pieces. Thousands of details. The color of eyes. The shape of ears. The spelling in letters. The memory of childhood events. The recognition by a mother. The identification by former neighbors. the testimony of ship captains and butchers and aristocrats and servants. The Tichborne case consumed years because there were so many details to examine. And we have spent hours on it for the same reason, because the details are endless, fascinating in their specificity, hypnotic in their accumulation. This is the nature of complex litigation. It is not dramatic in the way television shows suggest. It is slow. It is methodical. It is tedious. It is the patient examination of detail after detail after detail. And yet, there is something compelling about this process. The slow revelation of truth through accumulated evidence. The gradual construction of a narrative from fragments. The satisfaction of seeing a picture emerge from what initially seemed like chaos. The Tichborne case rewards patience. It rewards attention to detail. It rewards the willingness to sit with complexity and let it slowly resolve into clarity. And so we come to the end of our long journey through the Tichborne case. We have followed Roger Tichborne from his childhood through his disappearance. We have traced the claimant's path from Australia to England, through 2 lengthy trials, to his conviction and imprisonment and death. We have examined tattoos and handwriting, eye color and language ability, childhood memories and physical measurements. We have listened to hundreds of witnesses, considered thousands of pages of evidence, followed the slow process of justice working its way toward truth. The case ended in 1874, 150 years ago now. Everyone involved is long dead. The estates have changed hands. Tichborne House itself is gone, demolished or transformed beyond recognition. The world has moved on. But the story remains. The Tichborne case, that Victorian sensation, that marathon of litigation, that study in imposture and identity. As you drift toward sleep, let the details of the case fade from your mind. Let the names blur together. Let the evidence and the arguments and the verdicts dissolve into the general impression of a long, slow process, a grinding of legal machinery, a patient examination of minutiae. Imagine the courtroom, warm with bodies, the afternoon light slanting through tall windows. Imagine the lawyers' voices droning on, asking the same questions in slightly different ways. Imagine the witnesses answering, sometimes confident, sometimes hesitant, sometimes confused by the passage of time and the strangeness of being in court. Imagine the document stacking up, page after page after page. Baptismal certificates, marriage records, ship manifests, letters in faded ink, photographs yellowed with age. Each document carefully examined, authenticated, entered into evidence, added to the growing mountain of paper that the case generates. Imagine the jury, 12 men sitting through months of testimony, trying to remember who said what when, trying to make sense of contradictions and complexities, trying to hold in their minds the vast network of facts and inferences that will eventually lead to their verdict. Imagine time passing slowly. Days that feel like weeks. Weeks that blur into months. The rhythm of the court, the morning session, the lunch adjournment, the afternoon session, the adjournment until tomorrow. Tomorrow and tomorrow and tomorrow. The Tichborne case is over now, has been over for a century and a half. The question has been answered. The claimant was Arthur Orton, not Roger Tichborne. The fraud was exposed. Justice, slow but certain, was done. But in our imaginations, in our memories, in the endless details we have explored tonight, the case continues. It exists in that eternal present where all stories live, where Roger Tichborne is forever boarding the Bella, Lady Tichborne is forever refusing to believe her son is dead, the claimant is forever approaching England with his impossible claim, the trials are forever unfolding in Westminster Hall. Let yourself rest now. Let the story fade. Let sleep come gently, easily, like the slow drift of a ship on calm water, like the gradual dimming of light at day's end, like the quiet closing of a book when the tale is told. The Bella sank in 1854. Roger Tichborne died, lost at sea, his body never recovered. His mother grieved, held on to hope, believed what she needed to believe. A man from Australia claimed to be Roger, was believed by some, doubted by others, ultimately exposed and punished. These are facts now, settled history, part of the long record of Victorian England, of Victorian law, of Victorian psychology and society. But they are also a story, a tale told to help you through the night, a narrative woven from court transcripts and newspaper reports and historical research, presented slowly, carefully, with attention to detail that mirrors the trials themselves. Sleep now. Let the Tichborne case join your dreams, if it must, as a gentle presence, a Victorian ghost story without horror, a mystery solved long ago, a tale of identity and imposture that has ended the only way it could end. The courtroom is empty. The witnesses have all gone home. The lawyers have packed their papers. The judge has retired. The case is closed. And you, having followed this long journey from beginning to end, from the shipwreck to the verdict to the quiet death of Arthur Orton in obscurity, you too can rest. The case is over. The story is told. All that remains is sleep. In the quiet years after the trials ended, after the claimant was imprisoned, after the sensation died down, life continued at Tichborne House and on the Tichborne estates. Sir Alfred Tichborne, the 11th baronet, remained in possession. He had been vindicated. His right to the estates had been confirmed by the courts after years of uncertainty. He could finally live without the shadow of the claimant's claim hanging over him. Alfred managed the estates, collected the rents, fulfilled the responsibilities of a Victorian landowner. He married, had children, lived the life that his position entitled him to. He was a minor aristocrat in a county full of minor aristocrats, managing his inheritance competently if not brilliantly. The estates themselves, those thousands of acres in Hampshire, continued much as they always had. The tenant farmers paid their rents. The crops grew and were harvested. The seasons turned. The ancient rhythm of agricultural life continued regardless of legal dramas in London courtrooms. The scandal faded but was not forgotten. The Tichborne family would always be associated with the case. When people heard the name Tichborne, they thought of the claimant, the trials, the imposture. This was unfortunate for the family but unavoidable. They had been at the center of the most sensational legal case of their era. Sir Alfred died in 1891. The title passed to his son, who became the 12th baronet. The estates passed with it. The succession that the claimant had tried to disrupt proceeded normally, from father to son, generation after generation, as it had for centuries. Lady Tichborne, Henriette Felicite, we have already noted, died before the trials concluded, in March 1868. She was buried in the family vault, her grief finally ended. She had lived her last years believing her son was alive, believing the claimant was Roger. Whether this belief brought her comfort or only deepened her tragedy is unknowable. Perhaps both. Roger Tichborne himself, the real Roger, has no grave that anyone knows. He died at sea in 1854, his body lost in the depths of the Atlantic. There is a memorial to him somewhere, perhaps, or a marker, but no grave with his remains. He exists only in memory, in documents, in the traces left by his brief life. The claimant, Arthur Orton, was buried in a pauper's grave in London, but his coffin bore that nameplate, Sir Roger Charles Doughty Tichborne. Even in death, the imposture continued, or at least the claim. Whether this was his choice or someone else's, we do not know. The estates, those properties that were the object of so much litigation, eventually passed out of the Tichborne family's hands. The old aristocratic families that had held land for centuries gradually lost it in the 20th century. Death duties, economic changes, social transformations, all these led to the breaking up and selling of great estates. Tichborne House itself no longer belongs to the Tichborne family. It has had various owners, various uses. The land has been divided and sold. The great estate that William Jennings, wait, that's the wrong case. The great estate that the Tichborne family held for so long has been scattered, parceled out, absorbed into the modern world. But the name remains. Tichborne is still a place name in Hampshire. There is still a Tichborne village, though greatly changed from what it was in Victorian times. And there are still people who bear the Tichborne name, descendants of that ancient family, though without the wealth and position their ancestors once held. The case itself lives on in legal history, in books and articles, in the occasional television documentary or historical novel. It remains one of the most fascinating legal cases of the Victorian era, endlessly interesting in its details, its psychology, its demonstration of how the law handles questions of identity and truth. Let us return once more to the question of evidence, to how truth is established in law, how certainty is achieved in the face of conflicting claims. The Tichborne case required the examination of hundreds of pieces of evidence. Each piece, by itself, might have been ambiguous, might have pointed in either direction. But accumulated, the evidence became overwhelming. Consider the process like building a wall, brick by brick. One brick does not make a wall. Even a dozen bricks do not make much of a wall. But hundreds of bricks, properly laid, create a structure that is solid, undeniable. The evidence against the claimant was built this way. The tattoo evidence, one brick. The language evidence, another brick. The handwriting, another. The physical differences, another. The witnesses who identified him as Orton, more bricks. His inability to remember details Roger would have known, more bricks still. Each brick might be imperfect. The tattoo evidence was disputed. The language argument, while powerful, had theoretical exceptions. The handwriting could theoretically have changed. Each physical difference could theoretically be explained. But the accumulated weight of evidence was too great. The wall became too high to scale, too solid to break through. The claimant could not explain away everything. He could not account for all the discrepancies. The story he told could not bear the weight of scrutiny. This is how truth emerges in complex cases. Not from a single dramatic revelation but from the patient accumulation of small facts, each adding to the weight of evidence, until the truth becomes clear. The jury in the criminal trial did not need long to deliberate. By the time the evidence was complete, the verdict was obvious. All that remained was the formality of announcing it. This is satisfying in a way. Justice works. Truth emerges. The patient process of examination yields results. The fraud is exposed, the impostor punished, the rightful heirs protected. But it is also somewhat sad. The process took years. It consumed vast resources. It damaged lives, even the lives of those who were vindicated, because years of litigation take a toll on everyone involved. And what of Arthur Orton himself? Was he a cynical fraud who deserved his punishment? Or was he a desperate man who saw an opportunity and took it, not fully understanding the consequences? Or was he, perhaps, deluded himself, convinced by others that he might actually be Roger Tichborne? We will never know his true thoughts, his real motivations. He maintained his claim to the end, or at least his coffin did. Was this defiance? Delusion? A final performance for those who still believed in him? The historical record gives us facts, what he did, what was said, what happened. It does not give us his inner life, his subjective experience. That remains forever unknown. There is a rhythm to a long trial, a pattern that repeats day after day, week after week. Understanding this rhythm helps us appreciate what everyone involved experienced. The morning begins with the court coming into session. The judge enters, everyone rises, the formalities are observed. The judge sits, everyone sits, the day's proceedings begin. Witnesses are called. They take the oath, swearing to tell the truth. They testify, answering questions put to them by the lawyers. The questioning is slow, methodical. Each point must be established carefully. Please state your name. Where do you live? How do you know Roger Tichborne? When did you last see him? Can you describe his appearance? Question after question. The witness answers. The lawyer makes notes, consults his papers, asks the next question. The other side cross-examines. Now the questions become more challenging, more pointed. The lawyer tries to find inconsistencies, tries to shake the witness's certainty, tries to cast doubt on the testimony. You say you remember Roger's eye color. How certain are you? When exactly did you see him? Could you be mistaken? Have you discussed your testimony with other witnesses? The cross-examination can last hours, days. The witness grows tired, perhaps confused, perhaps irritated. But the questions continue. After the cross-examination, there may be re-examination, the first lawyer asking questions again, trying to repair any damage from the cross-examination. Then the witness is finally dismissed, allowed to leave the stand. And then the next witness is called. And the process repeats. Examination, cross-examination, re-examination. Hour after hour. At some point, the court breaks for lunch. The judge retires. The lawyers and parties leave the courtroom. For an hour or two, there is respite. Food, conversation, rest. Then the afternoon session begins. More witnesses. More examination. More of the slow, grinding process of establishing facts. Eventually, late in the afternoon, the day's session ends. The judge announces that the court is adjourned until tomorrow. Everyone rises as the judge leaves. The courtroom empties. And tomorrow, it will all happen again. And the day after. And the day after that. Week after week, month after month. This is the rhythm of a long trial. It is repetitive, exhausting, sometimes stupefyingly boring. But it is also the process by which justice is done, truth is established, cases are decided. Those who sat through the Tichborne trials, the jury, the lawyers, the reporters, the spectators, experienced this rhythm for over 3 years total. It shaped their days, their weeks, their lives during that period. And we, having followed the case through this long narrative, have experienced something of that rhythm ourselves. The patient examination of details. The repetition. The slow accumulation of evidence. The gradual movement toward conclusion. It is late now. You have been listening for a while. The story is nearly complete. The details begin to blur together, as they should. The names become harder to hold onto. Roger Tichborne, Arthur Orton, the claimant, they merge, separate, merge again in your mind. This is natural. This is how memory works. The specifics fade. What remains is the general impression, the overall shape of the story. A man lost at sea. A mother's grief. An imposter. A trial. Truth eventually revealed. Let the details go. They have served their purpose. They have carried you through these hours, have given your mind something to follow, have created the gentle rhythm that helps you towards sleep. The courtroom is quiet now. The candles have burned down. The winter sun has long since set. The streets outside are dark. Victorian London sleeps. The Bella rests on the ocean floor, broken and scattered. The storm that sank it has long since passed. The sea is calm, has been calm for a century and more. The ship's timbers are rotted, dissolved, returned to the elements. Roger Tichborne's bones, if they remain, lie somewhere in that vast ocean, mingled with sand and shells and the other remnants of the sea. He is part of the ocean now, has been for lifetimes. Lady Tichborne sleeps in her family vault, her grief ended, her hopes and fears all past. She found no closure in life, but death brings its own closure. Arthur Orton sleeps in his pauper's grave, his false nameplate rusting, his story told and ended. He tried to be someone else and failed. But perhaps, in some way, he succeeded, he is remembered, his name spoken, his story part of history. Not as Roger Tichborne, but as himself, Arthur Orton, the Tichborne claimant, the most audacious impostor of his age. The lawyers and judges, the witnesses and jury members, all sleep now too. Their work is done. The case they labored on so long is complete. The verdict stands. Justice was done, or at least the best approximation of justice that human institutions can achieve. And you, who have followed this story from beginning to end, from the Bella's departure to Arthur Orton's death, you too can sleep now. The tale is told. The case is closed. All that remains is rest. Let these be the last words of our story, the final thoughts before sleep claims you completely. The Tichborne case was about identity. Who we are. How we know who we are. How others know us. Whether identity is fixed or fluid, certain or uncertain. It was about grief and hope, about a mother who could not let go, who chose belief over acceptance, illusion over painful truth. It was about imposture and performance, about how we present ourselves, how we claim to be someone, how those claims are tested. It was about evidence and truth, about how facts accumulate, how certainty emerges from uncertainty, how justice is slowly, imperfectly achieved. It was about Victorian England, its laws, its society, its obsessions, its anxieties. It was a window into a world now gone, a world of rigid class structures and emerging social mobility, of ships and telegraphs, of empire and industry. But it was also timeless. The questions it raises are eternal. Who are we? How do we know? Can we trust appearance, memory, recognition? How do we establish truth when different stories compete? These questions do not have simple answers. The Tichborne case did not resolve them permanently. It only showed how they played out in one instance, one case, one long Victorian trial. And now the case is done. The story is complete. The details you will forget, most of them. Perhaps you will remember that there was a shipwreck, a claimant, a trial. Perhaps you will remember the general shape of the story. Perhaps, by morning, even that will have faded, will have merged with your dreams, will have become just another memory of something once known. This is as it should be. Stories are meant to be told and then released. They serve their purpose and then drift away, like ships disappearing over the horizon, like the Bella sailing from Rio de Janeiro on that April morning in 1854, carrying Roger Tichborne toward his unknown fate. Sleep now. The Tichborne case is over. The trials are concluded. The verdict is rendered. The sentence is served. Arthur Orton is dead. Roger Tichborne is dead. Lady Tichborne is dead. All the principals, all the witnesses, all those whose lives were touched by this case, all are gone, all are at rest. And you can rest too. Let go of the story. Let go of the details. Let go of the questions and answers, the evidence and arguments, the long slow process we have followed together. Rest. Sleep. Dream, if you dream, of other things. Of calm seas and safe harbors. Of identities that are certain and fixed. Of truths that are simple and clear. Of justice that is swift and sure. Or dream of nothing at all. Simply rest, deeply and completely, as the Tichborne claimant rests, as Roger Tichborne rests, as all those involved in this long Victorian drama rest. The case is closed. The story ends. Good night.